Is this the miss? Is this?
That is the missing page.
This
Yes.
is the.
So that goes in the authorities fund tab 5, please, in the appropriate place. And my apologies for not spotting that.
Thank you very much. Yes. Yes, Ms. Gumble.
Thank you, my lord. If I can turn to DFS and the argument in that case in respect of assumption of responsibility, and I will try just to go to the passages that deal with that as opposed to the various other issues in the case. I think the starting point is paragraph 16 on page 161 in the authorities bundle. Under the heading existence of private law duty of care, at paragraph 16, the matters relied upon by the claimants as to the foundation of the asserted assumption of responsibility of the re-amended particular claim. This was a case that had been started well before Thien and Pools, so it was pleaded on the basis without recognising the assumption of responsibility issues. And there were a number of amendments to the particulars of claim. Round to 22 paragraphs, each one identifying an action or response by the Social Services Department to concerns about the welfare of the claimants. Those 22 paragraphs assert reliance by different people or agencies, depending on the identity of the person or agency, raising the concerns. The claimants now rely, however, on 3 events to support their case that the defendant assumed responsibility for their plight, therefore owed them a duty of care to keep them safe. The first was the commissioning of and response by the Social Services Department to a psychology report prepared in January 1997 by Dr. Warren and Dr. Bell of the Rayside Clinic, which was known as the Rayside Report, and that was commissioned for seeing whether the children would be safe being left with a father who was a Schedule 1 offender.
Yes.
The second, the direct work undertaken by social workers and family support workers with the parents and the children to educate them as to the risks posed by third parties, and when we come to it, that was the one aspect in which the learned judge found there could be an assumption of responsibility, but on the facts of this case, that had been carried out responsibly, and therefore, and I'll take your lordships and my lady to that passage in a moment. And then the assessment in February 2002 that the claimants were at risk of significant harm, and the decision to commence care proceedings in March 2002 as a consequence of that assessment, the alleged defendants assumed responsibility to the claimants for competently pursuing such proceedings whilst it remained necessary to do so. And in A and C, the judge found that wouldn't amount to an assumption of responsibility on the facts. B could have done, but didn't on the particular facts of this case give rise to...
Did she say she didn't have to decide it, or did she actually say there was an assumption of responsibility, and therefore a duty was owed, but there was no breach?
Find the passage, I'm sorry.
I got the impression she didn't finally decide it, but in which case, which is good enough for you, actually.
Where do we find this considered?
The decision is at paragraph 202, page 202.
Yes.
In relation to each point. Sorry, it's 210 is in relation to the keeping safe work, but if I just go through in order in paragraph 202, Ms Gumbel's argument that the defendants assumed responsibility by obtaining the Rayside report, perhaps her strongest point, at least in this context, defendants can be said to have taken a step in the sense that it had done something. However, the Rayside report was obtained not for the claimant's benefit or for the benefit of the parents, but for the benefit of the local authorities in determining the parents' ability to keep the children safe. The the level of risk which their father posed to his children, and whether the threshold for registration or care proceedings was met, is obtained and funded as part of the defendant's assessment of risk under section 47 in order to assist the social workers acting on behalf of the local authority to determine how best to fulfil their statutory obligations. I take into account for the purpose of considering whether such a duty had arisen be sufficient if viewed objectively, be reasonably foreseeable the claimants would rely upon the defendant discharging its functions with reasonable skill and care. But as Miss Rigger and Miss Schofield confirmed, the local authority's assessment of risk may not be shared by the parents nor the children. Had proceedings been commenced, the parents would have been separately represented and the children's interests represented by a guardian ad litem. It would not necessarily follow that the local authority's viewpoint would be aligned with that of the family, children or parents. In those circumstances, I don't accept it would be reasonably foreseeable. Claimants would rely upon the defendant such as to give rise to a duty of care. The way we had put it was that if they do an assessment, it's reasonable that children whose plight will be determined as to whether they're left with a Schedule 1 offender or not, should rely on them to follow the report if it necessitates them being removed. The fact, but that was the finding in that respect, and I can't say that we accept that that's necessarily right. There are circumstances in which a report is obtained for the purposes of seeing whether the children are safe with a Schedule 1 offender, we would say is a reasonable basis for saying you have assumed responsibility to look into whether these children, these particular children, are safe with this particular
But isn't the
Schedule 1
whole
offender.
point that when the Rayside report was commissioned, the father had a recent conviction, but it was for indecent assault of a teenage girl or teenage
Yes.
girls, and the children were much, much younger, and the conclusion was, basically, he's not a risk to small children, but let's keep an eye out until they reach puberty, in which case the risk may change.
My lady, exactly, but we would say that they'd assumed responsibility for keeping that eye out by getting that report that gave them that warning, and when the children came towards puberty, they didn't implement the recommendations, particularly as by the time that happened, the children were being left with other Schedule 1 offenders and all sorts of other things were going on.
But that's a different risk, isn't it? I mean, by one of the pleaded allegations was that they should have taken care proceedings, I think, in 2002. Is that right?
Yes.
Yes.
Well, had any of the children reached puberty by 2002?
They were close to puberty. I think they were 10. I need to check the ages, but they were, because the Rayside report had been.
It was 1996.
So I think they were.
So I think there's a paragraph in the judgment that sets out the ages of the children. Paragraph 2 of the judgment.
Yes, page 158.
So in 2002, which was the first allegation about when care proceedings would have been taken, they were all still quite young. Now, they were older in 2010, which is the point at which I think care proceedings were eventually, an application for care order was made. But in 2002, those children were all still pretty young, weren't they?
Well, they hadn't actually reached puberty, but they were moving towards puberty and needed the position needed to be kept under review, is what.
Well, the oldest child was born in 1995, so she was 7 in 2002.
Can I understand, are you saying that you submitted to Mrs Justice Lambert and submit now that the seeking of the Rayside report in January 1987 or earlier amounted to an assumption of responsibility, and that paragraphs 202 to 203 where it said that it wasn't the assumption of responsibility. You're saying that's wrong, are you?
Well, my lord, in effect, yes, because
Right.
we say if you seek a report in order, the purpose of seeking, what we say is wrong, is that the seeking of the report was only for the purposes of social services, because in our submission, it makes a bit of a nonsense of having a social services department spending public money on investigations if the only purpose of it is to assist the social services department. The ultimate purpose must, we would say...
Just a moment, please, Mr.
Sorry.
Oh, I see. Okay, all right. Sorry, it's just apparently somebody has lost their laptop, and security was wondering if we could ask whether everyone can check whether they've got their own laptop and not somebody else's.
Sorry about this.
That's all right.
Have I asked the right question?
Has anybody got somebody else's laptop?
Yes, everybody came through together and everything took their laptops out, and obviously one's missing. He's obviously got barristers.
Yes. It doesn't look as though it's
No.
in this court. Thank you very much.
They do apologise.
I think that
So you were saying, what was,
that to rule out an assumption of responsibility I think it's the reasoning that we would quarrel with, of ruling out an assumption of responsibility and obtaining a report, independent report, in relation to the safety of particular children with a particular Schedule 1 offender, to say that that is only for the purposes of the local authority and has no purpose in protection of the children, and that the children can't rely on them implementing the report. Whether it was implemented or not, whether they could have waited longer than age 7 is obviously a completely different issue. But in terms of whether obtaining a report about the safety of children can be said to be only for the purposes of the authority, not to have a purpose in protecting the children on which the children can rely. I mean, if the facts were that the children were already teenagers and if they obtained a report, this is not the facts of this case, but just to illustrate the point, if they obtained a report in relation to the safety of two 12-year-old girls and the independent report said these girls are at immediate risk of being raped by their father, you should remove them immediately, would the same rationale apply that report was only obtained for social services if they ignored the conclusion these children were at immediate risk and didn't remove them? Could it really be said that there was no assumption of responsibility because it was only obtained for their purposes, they could ignore it, and the children couldn't rely on them following the recommendations? That would seem, to me, a curious state of affairs, that the children cannot, in any circumstances, rely on an independent investigation that is obtained for their protection purposes. And why is money being spent on it unless it's intended to be implemented to protect them? I appreciate on the facts of this case it can well be said that the time hadn't yet come that they were at risk in accordance with the findings of the report. But if it had placed them at immediate risk and had been ignored, the same argument would have to apply, that there'd be no assumption of responsibility.
That's what I'm trying to explore. 202 and 203 seems to give two reasons why seeking a report specifically on a risk presented by a father with convictions doesn't amount to an assumption of responsibility. And I'm simply looking at assumption of responsibility. And you're disagreeing with the part there that says this was really done by the defendant as part of its statutory functions, and you're saying no, the context was it was obtained by it as part of its functions because it had assumed, in effect, responsibility to do something to protect the child. And you disagree with 203, or do not disagree, which says there would have been no reliance because, separately, and just second reason now, the interests of the children and the parents wouldn't be necessarily represented by that report. and they would have had their own reports as to whether or not the father was at risk and they should be removed.
Well, I would say that is missing the point as to whether the children can rely on the local authority to follow the recommendations. Because if the recommendations are obtained for the purpose of keeping the children, of seeing whether, on my much simpler example, and I think the point is illustrated better by the example of a report being obtained as to whether 2 12-year-olds are safe, the report saying, no, they're not safe, this one presents an immediate risk to them, and the local authority did nothing in that situation. Can it really be said that those children couldn't rely on the local authority following the recommendations of a report it had obtained for the very purpose of seeing whether they were safe or not? And in those circumstances, it would be my submission, it must be that the report is, in obtaining a report to see if children are safe, they are assuming a responsibility to those children, and the children are entitled to rely on them following the recommendations if the recommendations are that those children are in danger.
So it's wrong in the second part, 203, to confuse reliance on the report, they might want a different report, with reliance on something different. The authority thinks there's a problem and they've got a report and they thereafter should do what they think right and do so non-negligently. So they're relying on the authority as assuming responsibility, irrespective of whether or not they agree with a particular report or recommendation at a particular time. That's what you're saying is wrong.
My Lord, yes, I'm saying they're relying on the local authority to act on the recommendations. I appreciate on the facts of DFX, it was much more blurred as to what the recommendations were. But in the example of a report that was very clear on the recommendations and that pointed to an immediate risk to the children, I would say, must be able to rely on the local authority to take steps to put the report before the court. Even if other people get other reports, it's then for the judge to decide. But the children...
So you say that the point made by the judge that the children will be represented by a guardian at any consequential care proceedings does not absolve the local authority of the responsibility
of doing, following the recommendations.
Of doing that which they think right and doing it non-negligently. But we're not dealing with how they implement it. Your point surely is the fact they've asked for a report because they've got concerns is of itself an indication that they have not washed their hands of this family. They're saying, we are taking steps, we are assuming responsibility. You may disagree with what we do, but that is the assumption of responsibility, you say.
My Lord, yes, and the children are entitled to rely on the recommendations to be followed through, whether that...
They're entitled to rely, you'd say, on the local authority doing that which they think right in the light of the recommendations, and to do so non-negligently. The reliance is on the local authority to take the appropriate steps, whether or not they agree with the report.
My Lord, yes, and whether or not the steps they take are negligent or not is the second...
Okay, yes, well, just to be clear about this, the local authority would not be obliged to follow, having received this report, to start care proceedings, necessarily. They could...
No,
so you're saying they were under a duty to take the recommendations into account in whatever decision they reached?
To do what was non-negligent in the light of the report. So in my Starker example, if it said these girls are at risk of being raped by their father at any moment, it would be negligent not to do anything about that.
But the point is that's not what the report said. Right. And if you read through the judge's very careful account of the interactions between the family and the local authority, you can see that the local authority social services department were in very frequent contact with the parent. They had regular case conferences and all the rest of it. And you will also see that they had in mind the recommendation of the Rayside report, because every now and again someone would say, well, he doesn't seem to be a risk now, but we do need to watch out when they reach puberty.
I mean, I fully appreciate that. What I'm saying is that the conclusion may be correct, but that the analysis of whether there's an assumption of responsibility, which is all we're looking at here, so looking at the details of that report is not terribly helpful in terms of looking at what's an assumption of responsibility.
Isn't the logic of your position that the report is almost irrelevant.
The content of it is, it's the fact of getting it.
It's the commissioning of it,
Yes.
I was going to say. And at what point do you say they, on the Rayside report, at what point do you say they assumed responsibility?
When
You say it was when they got the report, when they commissioned it, when they were deciding to commissioning it, when they got information which ought to have led them to think about whether to commit. Where exactly? This is the key point, isn't it? Where exactly does the assumption of responsibility arise?
Well, we would say the assumption of responsibility arises when they decide there is such a risk posed by children living with a Schedule 1 offender that we need to get independent advice as to whether it's safe for these children. That's a very responsible step that they're taking. They're saying, we know that living with a Schedule 1 offender is a risky business for young children. We need to know what is the level of the risk in order to protect these children. And we would say, in getting a report, the responsible thing to do, to see whether these children are at risk or not, they're assuming responsibility. And one of the arguments that I made is, well, if they'd done nothing, you'd say they wouldn't assume responsibility. If they do something, they are...
Yes, as Milady's pointed out, the report didn't say in categorical terms, these children are currently at risk and you should remove them.
Well, that's why it may not have been a breach in this case, but it's not why there wasn't an assumption of responsibility. And all I'm trying to address at the moment is why we say...
Well, so you say the assumption arose because there was such a risk from a Schedule 1, there was a risk from the Schedule 1 offender that required them to get a report. That's when you said the assumption arose.
Can I ask a further question, please? What is it an assumption of responsibility for? That's rather important, because there's one thing saying in the air it's an assumption of responsibility, but for doing what?
It's an assumption of responsibility for seeing whether these children are safe living with a Schedule 1 offender.
Right, but the report allayed that fear because the report said he doesn't seem to us to be a risk to small children and just keep it under review when the girls get close to puberty.
But that goes to whether there was a breach in leaving the children there having got it. It doesn't go to the issue that I'm asked to address from this case, which is what do you say are the assumptions of responsibility? The fact that the judge may rightly have found there was no breach doesn't mean there hadn't been an assumption of that goes to the breach as to whether on the wording of this report it was non-negligent to leave the children there as they approached 7, 8, 9 years. That's a different point. The point that I thought I was being asked to address is what is the assumption of responsibility here? Is getting a report an assumption and is there reliance on it? And I'm saying by illustrating it with starker facts that the children would be relying on the getting of a report being a step that is specific to their protection in a specific situation, and that they do rely on the local authority if the report did find they were at immediate risk. Appreciate, my lady, it didn't, but had it, then why wouldn't there have been an assumption of responsibility?
Well, okay, so your case is that there was an assumption of responsibility when they commissioned the report, or when the risk arose which ought to have led them, which a risk emerged which led them to commission the report, when they became aware of it.
It's the fact they
Well, supposing the report had said, having analysed this, there is no risk. At that point, what would happen to the assumed responsibility? Would it fall away?
No, they just still assumed a responsibility, and the children would still rely on them acting responsibly, but there would be no breach by not doing anything because the report was telling them not to do anything.
Would they have to do something 5 years later, 2002, because of the report in 1997, if having assumed responsibility, having been told about there was nothing to worry about in 1997, would the fact of commissioning a report in 1997 give rise to an assumption of responsibility in 2002 if something did happen in 2002?
Only if the report, as it did here, said that the children could be at risk as they got towards puberty, or if, in fact, the other thing I'm reminded it said was, or if there was marital disharmony. And there was, in fact, marital disharmony here, because that was one of the things the report said could give rise to the father posing more of a risk. And we say, having flagged up risks that needed to be watched for, they had assumed responsibility to look at those, whether those risks materialised, and the children could rely on them to do so responsibly. Whether there was a breach and whether this report was specific enough seems to me to be an entirely separate issue to me giving examples of what we say was an assumption of responsibility. And what we quarrel with is the reason why it wasn't an assumption of responsibility, not with the determination that this wasn't enough of a risk to remove the children later on, which is, I would categorise as being part of the breach aspect of the case, not the is there a duty of care aspect of the case. And I think it's eliding the two to say, but it didn't really tell you that you did have to remove them. That's breach, not assumption of responsibility. Well, that's how I analyse it, that when you're looking at assumption of responsibility, you're doing so regardless of whether there was anything that needs to be done or not.
May I just ask a question about the facts? As I understand it, the judge didn't make any findings about whether or not the children had been sexually abused, but the local authority accepted, which is recorded in the head note, that RFX had been sexually abused by her father twice between 2008 and 2021, and by another man in 2001 or 2002. So is that the extent of the findings or concessions about sexual abuse on the facts, or is there something else? I just want to make sure I understand the facts.
No, I'm sorry. There's the problem in this case was that the children had learning disabilities.
No, I understand all of that. I just want to understand what were the accepted or the found facts about the sexual abuse that had happened.
Yeah, the accepted findings were the findings that are set out there in terms
In the
of
head note.
sexual abuse.
Yeah, okay, well, thank you.
There were other allegations about them being left with other Schedule 1 offenders and various things, but the difficulty was they couldn't relate what had happened to them, which meant they needed even more protection.
Your case ultimately, as you reminded us earlier this afternoon, was, as set out in paragraph 16, that there were 3 events which you relied on in support of your case of an assumption of responsibility. Can you help me as to where we find the judge dealing with B?
My lord, yes,
We've looked at A, and I think we've looked at C, haven't we? But where does she deal with B?
Is it 204?
204, in relation to the direct work, is paragraph 210.
Yeah, 204 is C, I think.
It's B.
204
Is
yes,
it?
the care.
Is 204 B or is it C?
204
C is the decision to commence care proceedings. So she deals with C, and 210.
210 is the direct work.
So the only bit that says, having had referrals from people who are concerned about the children, and having decided to take advice, or having decided to recommend that the middle management people take steps to take the children into care, the only reason why Mrs Justice Lambert says that didn't amount to an assumption of responsibility is the last 6 lines in 204, isn't it? A recommendation that care proceedings be commenced in the way that I've described for the purpose of sharing parental responsibility cannot, it seems to me, to be described as a positive act which had the effect of generating a duty of care, nor characterised as the provision of advice or service upon which the claimants might reasonably rely.
Where are you reading from?
The bottom of 204.
204.
Yeah.
That's the reasoning on C, which is the not taking care proceedings, having decided that you were going to.
That's B, isn't it, not C?
Well, it's second in this, but it's C at page
16.
161. Page paragraph 16. The order
Oh, I
gets.
see, yes, okay, right, the C there, right.
What you told us was that, in respect of B, the judge accepted that could give rise to an assumption of
No, I'm
responsibility.
sorry. Yeah, in B
Yeah,
in 16. which
Yes,
is
and that's
the-
dealt with out of order.
Uh,
No criticism of the judge. At 210,
my lord, yes.
But she doesn't say whether there was or was not an
But she
assumption
said
of
it could
responsibility.
do.
You keep, no, I'm sorry, Miss Gumbel, that's a misuse of language. If a duty of care was generated by this work, she appears to be avoiding committing herself, and
Yeah.
it's a point in your favour. She doesn't say it could be, she simply says, I don't need to decide.
it's open.
It's
And that's
open.
relevant, perhaps,
Yes.
for HXA.
It helps them, yeah.
It does help you. The Lord mentioned that point,
Yeah.
2:05.
Yes,
Actually, it does.
it does help.
It doesn't that
One
help you?
analysis.
That means, arguably, the point about
Direct work.
diary that they keep safe workers at large.
There hasn't been a decision. Poole doesn't, you would argue, I imagine, that Poole doesn't deal with that context. Somebody saying, I've got to give advice to these children, they've got to be careful in that home because of what's happening there. And the question is, did DFX say that can't give rise to a duty of care? And the answer is, Mrs. Justice Lambert didn't have to decide it. To that point, it's still open, is the way I thought you were going to argue it, but it's not for me to put your case for you.
No, my lord, yeah,
Is that right?
wasn't ruled out as assumption of responsibility, is what we're saying.
It was neither ruled in, nor was it ruled out.
So it's at large. Large is the right way of putting it.
But
So
we-
it's open to you to argue it, whether we
Yeah.
accept it or not. It's not.
It's not precluded.
It's not precluded. It wouldn't be precluded, obviously, because this is just Lambert's
But-
first instance. But nonetheless, it's not been decided by this case.
Yeah.
Do you agree with that?
Mm.
We agree. We agreed.
But that perhaps
All right.
identifies the difficulty of each case looking at what's been decided in another case in different circumstances, and that's we say the danger of looking that's occurred with all of these cases is it's looking at another case and saying, well, that was ruled out as an assumption of responsibility. Section 47 investigations, they're a no-go area. Taking care proceedings, that's a no-go area. And
Well, what do you
have
say
got
about
to look
taking
at
care
that.
of these? What is wrong with 204 and her analysis there about B? Is there anything wrong? If so, what is wrong? When she says a recommendation, the care proceedings, don't forget the recommendation comes after lots of comments have been made raising concerns. So the culmination of that, a recommendation cannot be described as a part of the act which had the effect of generating a duty of care, nor the provision of advice or services upon which the claimants might reasonably foreseeably rely. So which bits, if any, of that do you say was wrong?
well, because we say that if you have investigated the plight of particular children to the point of saying we need to institute care proceedings, you are then assuming responsibility for carrying through that decision that it's necessary to institute care proceedings, and that the children implicitly can rely on you doing that. If you've got to that threshold, you must have assumed responsibility for carrying through that task that you think is that social workers have assessed, and what happened was a different social worker took over who reversed the decision. But if the threshold for investigating and instituting care proceedings has been reached, that team has assumed responsibility in terms of those children for taking the proceedings that that social work team think are necessary.
Right.
Whether it's a breach or not, again, is
Another question, yes. And here, there were lots of things that were happening between 1995 and 2002, when this conference recommended that legal proceedings should be started. That was on the 20th of March 2020. So it was only the recommendation at the Child Protection Conference that gave rise to the assumption of responsibility, satisfying the need for duty of care. All the previous referrals you seem to have accepted here between 1995 and 2003 didn't give rise to.
Well, I'm not sure I'd accept that none of those could amount to an assumption of responsibility. What I'm saying is the culmination must amount to a
But the duty of care, arose on the 20th of March 2002.
In terms of taking care proceedings, and part of the reasoning for that is, for the other aspects of the case, that for causation purposes, it's only the not taking care proceedings which would have made a difference to the children. So we had to have in mind what were the assumptions of responsibility, where if we could establish breach, there would also be causation.
So the decision, sorry to interrupt, the decision to take care proceedings was a decision that they should be started for the purpose not of removing the children, but to enable the local authority to share parental responsibility. That's at paragraph 104. So it wasn't a decision that at that point that the children should be removed, as I understand it.
Well, it was a decision that care proceedings should be taken so that the court would decide whether they should or shouldn't be removed. The purpose of taking care proceedings is to ask the court and to put before the court the
But if
material.
the local authority weren't pushing for the children to be removed, is it likely that the court would have thought, oh well, local authority aren't pushing for them to be removed, but they should?
Well,
They might have granted the care order with the children remain at home. There's various complexities to try.
Yeah, sure.
On that.
But that depends.
That depends on that being approved. There's a lot of
And full
regulation about
investigation of the facts, but it at least gives the opportunity for the court to decide whether the children are safe or not. And the argument in this case was that no court reasonably looking at all of these facts would have not made care orders, as indeed they were made later on.
Can I look at 205?
8 years later.
Sorry,
205.
So what? So 205 is where the judge, Mr. Lambert, starts thinking about or dealing with your arguments, and she says, like Lord Reed, I see nothing about the nature of the statutory function which the defendant exercises, which gives rise to a duty of care. And she says that you pointed to you hadn't pointed to anything which would, either in the context of obtaining the report or in the context of the decision made in 2002, which entailed that the local authority assumed or undertook responsibility towards the claimant to perform its functions thereafter with reasonable care, skill and care. Is there anything which you want to draw our attention to now about that case which would suggest that the judge made the wrong decision on that point?
Well, I mean, all I can say is we said what we're saying now, which is obtaining the report is assuming responsibility because you're obtaining it for the purposes of looking at whether the children are safe or not. And if you don't think that's an assumption of responsibility, the judge didn't, you reject my argument. If you do think it's an assumption of responsibility, the judge is wrong. I mean, it's as simple as that, I'm afraid.
So it's just once they obtain the report, they decide to obtain the report, that's an assumption of responsibility.
My lord,
And
yes.
they're responsible thereafter.
Well, they're responsible for not ignoring it, but following through the recommendations. Because, as I asked in that case, and asked this court, why should public funds from Social Services Department be expended on obtaining an independent report from psychiatrists, I think it was at the Tavistock, to see whether children are safe or not, if it isn't for the purposes of assuming a responsibility for those children's safety?
I mean, presumably by this point in the trial, the judge had seen all relevant local authority documents about this, the commissioning of the report, and the analysis of its conclusions.
My lord, yes.
Yeah, she reviewed a lot of documents.
So that was the basis upon which she reached the conclusion at 202 to 205.
But what I'm saying in the context of this appeal is that I don't accept for the purposes of this appeal that it is right that there cannot be an assumption of responsibility
Okay.
by the obtaining of a report.
So in
That's
fact,
all I'm saying.
the point I just made help you, because the judge reached her conclusion after trial, having seen all the material, that there was in fact no assumption of responsibility. You're saying it doesn't follow from that there could not have been an assumption
Indeed.
of responsibility
That's
in the
exactly what I'm
circumstances of
saying.
that case.
That kind of action needs the investigation of a trial. This trial judge, having investigated it, found there wasn't a breach, there wasn't causation, and
Well, not that there wasn't a duty in that respect. That's what she found.
Yeah.
well,
Did she?
yes.
That's the point.
But she found it wasn't an assumption of responsibility, and we do, I'm afraid, quarrel with that for the purposes of this appeal.
I think you need to say he's arguably wrong, actually.
I mean, do you need to go as far as that? Because, as I said, this was after trial.
Because if you look at paragraph 45, the judge makes the point that the documents were very extensive. Social services running records extend to thousands of pages.
And at 50 onwards, she deals specifically with how the Rayside report came to be dealt with at 55 onwards, how they did deal with it.
Was there an application to strike out this case?
My
No,
Lord,
Mr.
there
Levison's
was,
shaking his head.
no. But my Lord, I think the only reason that I'm saying we do need to quarrel with the conclusions of the judge is the paragraph 203 that we do say that, which is that there can't be an assumption of responsibility because of the report being obtained for social service. That's really the aspect that I challenge in terms of the analysis of assumption of responsibility. I don't need to challenge anything else because everything else is fact sensitive. But I think it would be wrong of me not to challenge that particular aspect of it, because that's what I've been challenging through my laborious trawl of the authorities in terms of where the law is developed as to what is being done for the local authorities' purposes and what must also have a dual purpose for the child. For example, in Phelps, and this is going back to the I would say this is going back to the Bedfordshire thinking that the insurance doctor only gets a report for the purpose of the insurers and the local authorities only do things for the purposes of carrying out their functions and never owe a duty to the subject of the investigation. And that, I say, got mitigated by Phelps and the idea that you could have a duty to the child as well. And I say that that is now not where the law is in terms of assumption of responsibility, that actions taken by social services are for their own purposes and not for the purposes of the child.
Okay, but I may be labouring your point. Are you submitting that we can't, in deciding whether it was right to strike out these cases, we should not draw any, and the judge was wrong to draw an analogy or to rely on what Mrs. Justice Lambert found after a trial?
What we say in that respect is that the approach that Lord Reed gave in Enham Pool, that it was whether there's an assumption of responsibility or not, is so fact sensitive that to be drawing any conclusions from what Mrs. Justice Lambert found in completely different circumstances as to where on the single point of where there can be an assumption of responsibility is muddying the waters in terms of whether there is on a particular case. And that's the fault we find with Mrs. Justice Stacey's decision as well, which is to look at what other people have done with particular actions of the local authority. And what action it is the local authority is taking is not the test of whether there's an assumption of responsibility on those particular facts.
Okay.
What we
Can we just
quarrel with
pause just a moment, sorry.
Well, what would help me to know, we've got to 3 o'clock. The one thing we have not looked at is the particulars of claims you're assuming are true. Because what I've always been saying to you, isn't it the case that if what you are relying on the facts of your case are indistinguishable from or weaker than Mrs Justice Lambert's assessment, then we'd have to perhaps be persuaded it was arguably wrong. And I wonder how we can have an appeal about a strikeout when we still haven't looked to see what you say amount to the assumption of responsibility here, because you can't just say, this is a child, this might have happened, therefore don't strike me out. You must be able to show us pleadings which show a case.
I do think we've come to the end of our trawls with the authorities, and we of course wanted you to go through DFOs after lunch, and I think
I'm
we
coming
probably
to that because I say that is where the strength of this case is that these facts are not distinguishable, and nothing in the authorities or the previous cases should have ruled out this being arguably an assumption of responsibility.
Should we now go to the pleading?
Yes. I'm afraid I came to DFX because that's what I thought I'd come.
No, you were right. You were right to come to DFS. But I think my Lord's right. We do now need to go to the pleading. So where do we go?
If we go to
Unless the lady has any questions. Okay, where are we on the pleadings?
in H, there are two separate bundles,
Yeah.
and if we go first to the
H
pleadings
first?
in the HXA bundle,
Page tab 13.
the particulars of claim at page 223 in that bundle is where they start. The sequence of events is set out before the basis on which it says there's an assumption of responsibility. But if I can pick out from the sequence of events that starts at page 229, facts that may give rise to an assumption of responsibility, but because we don't have all the documents, there are obviously...
Yeah, but we've got to work on the pleaded case. That's what
Indeed.
we've got to look at. It's not enough to speculate that it might be amendments. It's clear from Poole that you've got to look at whether the pleaded case does. So it isn't going to help us to say, these are the pleaded facts, but there might be others.
So what is pleaded in terms of the events, and then I'll come to how that's pleaded as assumption of responsibility, because that's the order of the pleading. The events start on page 229. The first one that may be relevant is G on page 230. 2nd of August, several neighbours visited the defendant's office to raise concern about the claimant's mother's verbally abusive behaviour towards the children and the lack of supervision afforded to them. So it's drawn to their specific attention about this family by other people who are specifically concerned about them. In J, in October 94, a referrer informed the defendant that she'd witnessed the claimant's mother leave the children unsupervised outside a shop. The elder children had attacked the second claimant and others had witnessed similar behaviours. The defendants took no action. So this is cumulative, the concerns raised by others as to whether, having been alerted, those people expected the local authority to look into it and to do something, whether they assumed responsibility for looking into it.
Well, this is they took no action for J. We don't know about G, but well, I suppose H says there were investigations about MEX, but you're saying that the mere fact that somebody refers a complaint or a concern to the Social Services Department, that equals an assumption of responsibility.
It won't always, but it will if they indicate that they will look into it.
Right. So on the 2nd of August 1994, had there been an assumption of responsibility or not?
Well, there had if they told the people who...
But you don't plead that. Sorry, go on. Plead.
Well, you need that for reliance, but...
Does G, as pleaded, establish an assumption of responsibility on the 2nd of August 1994?
It doesn't without reliance as well, but it sets the background ground for where there would have been an assumption of responsibility if there was reliance. And all
Well,
this is
just
doing
so I
is
know,
looking at the event.
just so I know, at what point do you say there was? Are you going to say there was an assumption of responsibility? What date do you say there was an assumption of responsibility?
Well, certainly November '94, which is the deciding to seek legal advice with a view to initiating care proceedings.
And that, of course, is the point that we've been looking at in DFX.
But in letter L, November 1994, there was a child protection investigation after the defendant received a referral alleging the claimant's mother had assaulted the first claimant. The defendant's social worker decided to seek legal advice with a view to initiating care proceedings. The defendant resolved to undertake a full assessment,
but did not do so. So you've had a referral, you've agreed to look into it,
you've looked into it
and thought we need to initiate care proceedings.
So the assumption of responsibility, you say, arose when they undertook to carry out an assessment but didn't. Yep. That was the point at which the assumption of responsibility occurred.
and the reliance is
When they say they're going to take care proceedings and they don't, the children implicitly, or if they actually knew, would be entitled to rely on them doing what they said they were going to do, which is the...
I'm confused. I'm reading L now. Just very simply explain to me whether L establishes an assumption of responsibility, and if so, how?
well. The defendants received a referral alleging there's been an assault.
Yeah.
They assume responsibility by looking into it and deciding that they need to institute care proceedings, or at least
They didn't
look
decide.
into it.
It doesn't say they decided to initiate care proceedings.
To seek legal advice with a view to initiating care proceedings, it says.
So you don't seek legal advice with a view to initiating care proceedings unless you think there's a basis for initiating care proceedings.
Or unless you've taken responsibility, and if the advice is yes, go for it, you go for it. That's your case, really.
My lord, yes.
But
That's the very thing that Mrs Justice Lambert said wasn't capable of amounting to a duty of care.
Well, that
And
comes
you say
back
that's
to where
just
we say
wrong.
we have to quarrel with the findings in relation, although we don't necessarily quarrel with the detailed analysis on the facts of that particular case.
Supposing the legal, it's not for us to ask what the legal advice was, maybe it is in this case, but suppose the legal advice has been you haven't got the grounds, would there still be an assumed responsibility?
Well, we would say there's been an assumption of responsibility, but there was no breach because they'd done the responsible thing, which was to take advice and to follow the advice. Which was
How long
not-
does the duty, the responsibility continues indefinitely, does it?
Well, no, the next assumption of responsibility would be another investigation where the
Hang on.
same...
So there's a different, sorry, so the responsibility came to an end and then it was assumed, and then there was a further assumption.
There would be, yes, there can be several events. I mean, that would...
It's not a continual responsibility from the moment of the first assumption. It doesn't go on forever.
No, that's why it's different from a continuing duty of care. It's an assumption of responsibility on particular incidents or events or actions. And if there is a discrete investigation instigated by a member of the public, they agree to look into it, they look into it, and so far so good, they're assuming responsibility for doing what they've been asked to do, they come to the conclusion that they should seek advice with a view to instigating care proceedings. If the children knew or implicitly knew that that's why the social workers were fussing around in their house and looking at things, is that they were there to protect them and they were going to take care proceedings. They're relying on them doing what is the right thing, and if they don't do it, it's a breach.
Well, when were the children put on the child protection register?
I think
It's not pleaded. The fact they're on it by
Well,
January.
it's E, I think,
on
isn't it?
several occasions.
Oh, it's already been, as I missed it.
Isn't it? E on the previous page?
Sorry,
E.
you're all right, my mistake, sorry.
229,
My
July
mistake.
94.
Sorry, thank you.
But, again, maybe it is my fault, and I do apologise. You seem to be saying there are two things. There needs, in effect, to be a state of affairs which constitutes responsibility lying now with the local authority, and it becomes a legal liability when there's reliance on the parts of the children, and the children need to know about it. As you argued in DFX, you're saying there's two things. There's the actions and there's the reliance.
Because
And the actions are the receiving of complaints and deciding to seek legal advice and or make a full assessment and reliance. You haven't pleaded any reliance here, have you? I don't see it in your pleadings.
Well, the assumption of responsibility is pleaded separately, but reliance in relation to children will nearly always be implied reliance rather than actual reliance, although we do say in relation to the report, when I come to it at
Having asked you to go to the pleadings, we then don't let you develop them, but you say G and J might have been relevant events, although you've also said that it doesn't establish assessment, but L, you say, is the first event which gave rise to an assumption of responsibility in the legal sense.
my lord, yes.
And what other things are you relying on other than that?
The
On the facts
other
of this
thing
case?
begins at W when they know that the claimant's mother has formed a relationship with Mr. Austin. Mr. Austin, this is the bottom of page 231, and this again.
I think he should be Mr. A, shouldn't he?
Yeah.
I'm sorry. In 1992, he was convicted of assault occasioning actual bodily harm to his own child and making the boy by shaking. So that's the background.
Mm-hmm.
And then the investigation in relation to that, which is relevant to the assumption of responsibility,
Mm-hmm.
is double V on page 235, 27th of January 2000, Child Protection Conference was held. It was noted that the first claimant had reported that Mr. Austin had touched her breast, so she had specifically reported it. That must be with a view to somebody doing something about it, because it's, as everybody knows, quite a brave thing for a young girl to do.
Which perhaps
VV,
VV, I'm sorry.
VV.
page 235.
Sorry.
So that's the second point. If you failed on the first point, the second point at which assumption of responsibility occurred was the 27th of January 2000, when they knew the background of Mr. A's character, and they'd received a specific report from the girl that there had been an incident of this nature, and the resolution not to investigate this is an assumption of responsibility, you say?
Yes, they
Or
are
the
investigating.
resolution to do safekeeping work was the point of liability, assumption of liability.
Well,
Which is
in,
it?
this is why we say you can't categorise particular events as being or not being an assumption of responsibility. We say that the Child Protection Conference on the 27th of January, where they were looking into a specific complaint that the child herself had made in relation to a sexual assault, they were assuming responsibility. But it doesn't mean that every Child Protection Conference has to be an assumption of responsibility, which is the difficulty in saying Child Protection Conferences are in or out of assumption of responsibility. On the particular facts of this case, holding a Child Protection Conference because a young girl has complained of a sexual assault by a father who they ought to have known had been convicted of seriously injuring his own child, was an assumption of responsibility. The child was entitled to rely on them competently looking into that complaint. And what do? They negligently resolve not to investigate because they don't like Mr. A's, the
unintended reaction of Mr A, and they negligently didn't look into the previous concerns. That bit obviously goes to breach, but the assumption of responsibility is to look into a specific child's specific complaint, and the way they do that in the assumption of responsibility is to look into that complaint. The child is relying on them to do so competently. The method by which they do so is the child protection conference. But I'm not saying, because on this occasion we're saying there was an assumption of responsibility in the investigation through a child protection conference, that every child protection conference is going to be a Lord Reed assumption of responsibility. What I am saying is that, at least arguably on the facts of this case, holding a child protection conference as the mechanism for investigating a specific complaint made by a child is that they hold a child protection conference. That's how they've assumed responsibility for looking into this particular event. This child has relied on them to do so competently, and there is then a breach in the fact that they don't do so competently. They miss out the most important aspect, which is the history they know or should be able to ascertain.
Sorry, when do you say the duty arose? When they decided to have the case conference? When they had the case conference and made certain decisions at it? I'm not quite clear when there was, you're now saying there was...
When they agreed to look into the complaint of the girl who said my father sexually assaulted me. How they do so is a matter for them, and on the facts of this case is the child protection conference. But
I've understood you to be saying because they decided a child protection conference to assess this assault from a known offender was the assumption, so whether it was the 26th of January or the 1st of January, it was the act of deciding something must be done in relation to this allegation involving this perpetrator.
my lord, exactly. And the fact that in other cases child protection conferences are not assumption of responsibility would be the wrong way of looking at it. And that's the difficulty of the way courts have been looking at this. They'd say, well, child protection conferences have been ruled out, therefore they're a no-go area for assumption of responsibility.
They haven't said that with respect. They've said you need something more. They haven't said they're ruled out. That's precisely what Pood and DFS
something more than the statutory duty.
Yeah. It's the very
By
opposite of
itself.
what you're saying.
But you see, let me just test your, if I may, we're dealing here with this obviously very serious case of in which very serious abuse occurred. All sorts of child abuse occurs, coming to the attention of the local authority. Let us deal with a neglect case, not arguably as serious as this sort of abuse, not as serious as this sort of abuse, but nonetheless harmful to children, and it can be significantly harmful and give rise to children being taken into care. Is it your case, and if not, well, I won't do that, it's too much, one question time. Is it your case that once a local authority has reason to believe a child is suffering a risk of suffering significant harm, an assumption of responsibility arises?
Only if they agree to investigate it, because doing nothing is not in the context of child investigation may well not, if for example someone rings up and says, I'm worried about this mother who's chastising her children, and they say, we're really pushed at the moment, we can't look into it, you better go to the police, or we're just not looking into neglect cases, we're only looking at, because we're so busy, we're only looking into sexual abuse cases, then they haven't assumed responsibility. They don't have to assume responsibility for everything that happens. But once, and I think it's well illustrated by the fact that once they're using public resources to go and look into it and get reports like the Rayside report, or hold a meeting where everyone's discussing this particular problem, I would say, why isn't that an assumption of responsibility that is affecting that child? And that child is entitled to rely on them to do that responsibly. And they may make decisions that are not what the child wants, but that will only be a breach, which is why I come back to the Bolam test, if it's so incompetent that it's Bolam negligent. But why shouldn't it be a breach of an assumption of responsibility duty if it's such an irrational, ridiculous decision that is putting this child at risk?
You know, if you get into irrationality, there's a whole area.
Well,
that's a very, very unwise
yeah.
route to go down,
But,
actually.
Yeah, that was probably
So
the wrong
let
word.
us say the social worker has 2 phone calls in 2 minutes. The first one is someone complaining about neglect. We think a child's been left alone. You know, an 8-year-old child's been left alone for a couple of hours as parents went down to the pub. Okay? And the social worker decides to investigate that. That decision is an assumption of responsibility. And the next minute, someone rings up and says, I've seen a man sexually abusing a child, and the social worker does nothing about that. I know it's an absurd.
No.
In your point, your argument would be there's an assumption of responsibility in the first case because the local authority decide to do something, but not in the second case because they don't.
Well, it would depend on the conversation, because if they said, we'll look into it, and they didn't, then there would have been an assumption of responsibility. If they said, we just don't have the resources, you better go to the police because this sounds serious, but we can't do anything about it, they would have to have some reason for not having assumed responsibility in the second case.
And if
But
they
it
didn't,
would depend on the
if
fact.
they didn't have a reason, what then?
Well, if they didn't have a reason,
Well, they forgot
and
to make a note, or they slipped that. You know.
then we would say they had assumed responsibility, but they'd acted negligently in doing nothing. If they'd left the impression they were going to investigate it, and it's a serious matter that requires them to, is leaving the child at risk otherwise.
The other difficulty I've got is this: if you go back right to where we started, section 47, I think it is, says they've got powers to investigate the situation where there may be a risk to the welfare of the child, whatever the phrase is. That's a statutory power. By exercising that power, they could stop somebody else harming the child. They could stop the mother, the father, a relative, or whatever. And on one reading of Poole, that of itself is not enough. The existence of a statutory power to investigate and the ability to prevent somebody being harmed by a third party doesn't, on one reading of Poole, equal liability. There needs to be something over and above. So when you say quite powerfully, but what about the children? Where can they go? What can they do? The answer is that isn't enough of an answer to the question of if all you've got is a statutory power to investigate when complaints or if matters are brought to their attention or of their emotion and a risk of harm to others, that according to one reading pool isn't enough. So don't you have to have more than saying, oh, well, they said they would investigate? The answer is no, they said they would exercise their statutory power. The question is, what then takes it outside the public law sphere and into the private law, and they must pay damages if they get it wrong?
Well, we would say that saying they're going to investigate is assuming responsibility. If they just have a power to investigate and they don't carry out wide enough investigations to see the risk that children are at, then that's not actionable. But if they are, and the assumption of responsibility is the taking on the specific task in relation
but that's
to
just describing situations. Your words, assumption of responsibility, can be changed because these are all words. And what you could say is instead of assumption of responsibility, they have resolved hereby to exercise their section 47 powers. And that's not enough, we know, if it's read like that on one reading. So you're rather switching and saying, because they're investigating, therefore they've assumed responsibility. But Poole seems to be saying the exercise of statutory power to investigate, which could protect other people, isn't enough unless there's something more. That's the difficulty that I'm struggling with at the moment.
Well, the something more is the case specific. What are they? Which is like the email that could have been an assumption of responsibility if it was under the Child Protection Act. They are saying they're going to do something in a specific case and investigate in a specific case, whereas the general duty to investigate gives them wide power, discretion as to where their resources go. And looking at it, it's not unreasonable, I would say, to look at where are they putting their resources. If they're putting their resources into investigating a particular case, getting, like the Rayside report, they are taking responsibility for that child and that child's welfare. They may have to make difficult choices about which children they're investigating.
But we're looking at the two things here, actually, which so far is L and VV, not the Rayside report now.
Yes.
And that seems to be covered by the second half of Miss Justice Lambert's judgment, which is that is simply the exercise of a statutory power which could have prevented harm to a third party, and there's nothing else. And we've gone over it, but is there anything else you want to say that is the something else for L and VV?
Well, in terms of VV, the something else is the child has reported that her father has assaulted her, and that it's perhaps a very good example of where there will be reliance, because if you get to the stage of reporting it and it isn't, and nothing's done, that is in itself damaging. I mean, it's not the way it's pleaded, but to give a report, and I've come to briefly just where assumption of responsibility is, how it's pleaded on page 237.
Before we leave VV, is the resolve to keep things safe work with the claimants, is that a separate thing which also attracts an assumption of responsibility, or is that something that you're not now pressing?
Well, no, that is the keeping safe work. The reason that is significant, and that is that the keeping safe work is providing a service, and that's within the Phelps criteria of the psychological services, and so that is a different.
It's not assumption of responsibility, but it's liability for another reason.
Well, it is assumption of responsibility to carry out, to provide services, and then a failure to do so. I mean, it could be said that that's outside CN and Poole and his provision of services that attracts the duty of care without assumption of responsibility.
That's what I want to know.
Yeah.
Are you saying that?
Well, that's ultimately the highest the case can be put, but in this case, we put it on the basis of there was an assumption of responsibility to provide the duty of the keeping safe work.
So this is still only relevant to liability if it indicates an assumption. I'm trying to understand your case now, just so I know what you're saying. You've said a number of things. Keeping the safe, which involves the provision of a service, will give rise to a duty of care if it involves the assumption of responsibility, and it does so involve the assumption of responsibility. That's my case.
Yes.
Okay.
And also, there's this potential distinction between doing the keeping safe work and other things, which is that would be the provision of a service, so it would be doing something positive rather than refraining from doing
An act.
something,
Yeah.
An act.
a positive act.
And it's not, as we've already established, it was left open in DFX.
Yes, that's the point, yeah. So those are the three facts, or the three paragraphs setting up the sequence of events which we rely on. And then you say assumption of responsibility is key in paragraph 15.
That's pleaded from paragraph 15.
And then in paragraph, there is some pleading of reliance, I think, in paragraphs 18 and 19, so there is a pleading about reliance.
And just so I've got it right, in the circumstances, they assumed responsibility when response was responded to. That's the 1994 and the 27th of March ones.
November 94 was the initiating care proceeding.
Yeah.
And the 27th of January 2000 was the Child Protection Conference, where they investigated the report made by the child herself.
And the resolution to do keeping safe work.
And the keeping safe, it's all in the same paragraph.
And reliance is, as the lady says, 18.
18 and 19.
Right.
And then
Sorry, there's also some reliance pleaded in paragraph 17.
Yes.
Oh, yes. And it's Implied Reliance. Will you say the whole thing was to look after the children? They're too young to know. What was it for?
Oh, yes, there must be potential for implied reliance, and that's why I referred to Kenton and Griffiths. There is implied reliance by the patient, but it's the doctor who gave the call. The patient didn't know what was going on because she was having an asthma attack, but that doesn't stop her relying on...
These children are young children. Yes. Right.
The only other matter, I think, is the particulars in the YXA case, which is...
Well, YXA is...
Oh, right. Yeah. Sorry, I'm asked just to point out that in terms of the keeping safe work, Mrs J Stacey found no causation, and we say on the...
Are you going to come to the judgment separately?
Right.
I think that... Would that help? Let's
Yes.
look at YXA.
I can take
Now,
YXA very shortly.
well, hang on a second. We've been looking at various statutory duties so far, section 17 and section 47. Do we have to consider any other statutory duties when we turn to YXA?
Well, the provision was in section 20 accommodation, so it comes under section 20 as to what was being provided, and we say that was providing a service of accommodation.
Well, under section, as a result of the child being accommodated, the child becomes a looked after child, and therefore the local authority has specific statutory duties. In addition to the general duty under section 17, it has specific statutory duties under section 22 and schedule 2.
Oh, yes. It's page 11 and 12 of the authorities bundle is where your lordship and my lady will find.
Well, I've got a red book here, which
Sorry,
and I've got copies
it's
of
in
it.
the bundle.
I've filched a couple from my colleagues. So, but I think you've copied it all fairly comprehensively.
Section 20 is at page 11.
Do you say what impact does the fact that this child was being looked after, not under a care order, but was looked after under respite foster care? What impact does that have on the assumption of responsibility?
While the child is in the section 20 accommodation, there must be an assumption of responsibility.
Yeah. And what about when the child? What about when the child is not? When the child goes home? Here, the child has one night in a fortnight and one weekend a month, or something like that, isn't it? So the child, therefore, in foster care, 4 nights a month. Is there an assumption of responsibility? Obviously, well, you say there's such responsibility when the child is being looked after.
Lord,
See if Lord Fawkes agrees with that.
We say.
What about when the child goes home?
Well, we say the assumption of responsibility to the child whilst it's being looked after must extend to whether you discharge the child back to an environment if it is an unsafe environment or not. And that if the parents objected to the child not being discharged back, that's when you would need to institute care.
Have we got copies of the agreement signed?
I certainly
Under
don't
section
think we
20
have.
there. I assume there was an agreement. There isn't always an agreement.
I think
There should have been a signed agreement. Have we got it?
Certainly, it's probably in the disclosure that we haven't yet got or haven't yet, and that's another issue on Strikeout that we don't have.
Yes.
The document.
Anyway, so how do you said that once? How do you put it? That once a child has been accommodated once and goes home, so is it home for 25 nights or 26 nights a month in foster care for respite foster care for 4, whatever it is, that the responsibility is assumed throughout the period, notwithstanding the fact that most of the time the child's at home. Is that how you put it?
Well, we say on the occasion that the child is received into accommodation, there's assumption of responsibility and reliance by the child that they are going to be looked after responsibly, and that part of the looked after responsible is not sending them back to somewhere where they will be harmed. So there's an assumption of keeping them safe while accommodated, but that can't simply be terminated by sending them back to what they've removed them from as a known danger. And it's just a continual, each time they're discharged, it's a breach of the assumption and duty in relation to their care in Section 20 accommodation.
Okay, so there is if a child is being accommodated on a respite basis, several days a month, whatever, then that gives rise to an ongoing assumption of responsibility.
Well, it's ongoing while they're in care, but it doesn't.
They're not in care; they're being looked after.
I'm sorry. While they're being cared for or
Well,
being looked after.
I mean, it's quite. I mean, looked after includes children in care, but also children are being accommodated.
My lord, yes. Well, whilst they're being accommodated, there is an assumption of responsibility. The child is relying on them, and relying on them not to be released to a danger. So that just as if they were released onto a road, you wouldn't say that once they're outside the building where they're being accommodated at the end of the period, if they were sent home alone, for example, when they were too young to travel alone, I don't think there'd be much doubt that that would be something for which the local authorities should be responsible, because the fact that the period of accommodation had ended couldn't mean that they then have absolutely no duties to keep them safe at all, and can let them out of the door onto a dangerous road.
Well, they might have assumed a duty to make sure they return safely to home, so they couldn't put a 4-year-old child on a 26 bus with 2 changes. But the question is, does the duty extend not simply to looking after the child physically whilst the child is in the accommodation or going to and from it, but whether there is also a duty, because of the assumption of responsibility during the respite period, to take steps to investigate and, if necessary, take the child away from the parents long term.
We would say they
You say
can't
they
go
do.
home safely because the home is not a safe place to release them to, and it's only a matter of degree whether it's the road between home and the accommodation or whether it's the home when they reach it. If it's known the home is unsafe, they have released the child to an unsafe place where they know they're being given 3 times the dose of medication they should be given. So the obligation must be to keep them safe and not to send them to somewhere unsafe, which is what they're doing by releasing them home.
So the fact that they've accepted, they've got to do something for the child at some stages, because that promotes or safeguards his welfare, necessarily means there is an assumption of responsibility, which could, depending on the facts, and you say that's all you need, indicate that they shouldn't be doing other things, even outside that narrow window of respite care, if that would give rise to the very same risks that he's in the accommodation in the first place to prevent.
But it is just a matter of timing. I mean, they shouldn't be, if the home is a risk, they shouldn't be, the position would be the same if they, factually the same, if the child was accommodated for a week and in the middle of the week they decided to send the child home for 2 days at home, and the child is therefore...
You would say, presumably this would be a good example, you would say, if the child was being accommodated because the parents needed respite care and they were losing their temper and they were shouting at the child. But if the social worker was driving the child back to the parent's house and the child said, please don't take me back there, it's not just the beating, it's the sexual abuse. You would say, the social worker then would say, well, hang on, I've got responsibility for this child, I can't take him back now.
Well, certainly in that situation, but we would say knowing why they're giving the respite care, which is the overdosing of the giving of 3 times the dose of medication that the doctor recommended. Every time the child is being sent back to that home, they know the child is being sent back to somewhere where it is unsafe because it's being over-medicated. And if they're giving respite for short periods, there is assuming responsibility for providing a safety to the child away from the home. Why is sending the child back not a continuation of that responsibility? It does seem very anomalous that there would be an assumption of responsibility if they agreed to accommodate the child for a week and sent it home for 2 days in the middle of that week. But if they send it home at the end of the week, there's no longer any responsibility. The responsibility must continue to seeing that it's not going somewhere unsafe at the end of it. The pleading of that is at page 33, is in the other bundle, the YXA bundle, and the particular claim begin at page 316. 331 is a heading, assumption of responsibility, but there were initially two defendants and it's discontinued against the first defendant, but I'll just point to the heading because it's at page 331. And so when we get to the second defendant at 334, that is still under the heading assumption of responsibility.
It's really 6.10, isn't it, you say?
Oh, yeah. That's the sole basis in that case, but it is an important basis in terms of these cases generally.
And there's nothing in DFX which is directly relevant to this?
No, there's nothing in DFX relevant to section 20.
Okay.
There's no cases there on section 20.
No.
No, there's nothing.
No.
If that really is, how does pool apply to that context?
Yeah.
Okay. Shall we? Should we look at the judge? The judges. Do we need to look at the judgments below, the first instance judgments, as well as Mrs J Stacey, or do you just want to look at hers?
Well, I had thought it's probably only relevant to look at Mrs J's
Okay. Right.
judgment.
So,
It's in both.
well, I'm looking at it as we've got. I don't know where do you want it? Looking at Y and Y, you've got it separately. I've got it. It's in Y, isn't it? It's at 83 in Y. Y is blank.
Yeah. And there is.
Can we go straight to her analysis at 63, or do you want to say anything about it? Earlier parts of the judgment.
No, I think it's the. Well, there's a. I hesitate to say it, but an analysis of other cases, and they're including DFX. There is analysis of the Strikeout Law, which, and I haven't come to my Stanton argument, although I wasn't really proposing to go through that, because I know Your Lordships and my lady have read it, but we do deal with the
strike out provisions in there.
So are we looking at
Okay.
63 on page 102? Or do you want to say anything before 63?
Well, I think it's 63 onwards, which is the
Yes.
analysis in relation.
Are you going to come to 65? Is that where we really have to focus?
My lord, yes, in terms of the investigating and monitoring and the analysis of the something more. But what we say is that the judge looked at other cases where the duty of care had not been found, and in order to assess whether there was something more, and we criticise that in the sense that the analysis on a strikeout application has to be: is there anything in the pleaded case that could give rise to an assumption of arguably give rise to an assumption of responsibility? And the emphasis on looking at other cases where the investigation decision to undertake a full investigation didn't amount to an assumption of responsibility is the wrong approach, and that's what I've been trying to emphasise, that the tasks don't necessarily assist with whether there's an assumption of responsibility in a particular case or not, whereas Mrs J Stacey is comparing the tasks which have been analysed in other cases in order to decide whether there can arguably be an assumption of responsibility in these cases.
So in other words, she's drawing inferences which are too general from the facts of particular cases.
My lady, exactly. That because in other cases a child protection conference or an investigation has not given rise to an assumption of responsibility, doesn't mean that on the facts of this case, and the HXA example of a child protection conference, as I've said, I don't pretend that a child protection conference is always going to be an assumption of responsibility, but a child protection conference investigating a particular complaint by a child who is wanting someone to look at what her father's doing to her may arguably be an assumption of responsibility.
So in other words, you can't draw a conclusion of law from the particular task that's being done by the local authority.
Indeed, my lady, and that's really the central criticism of the approach, is that it looked at tasks as not having in other cases amounted to an assumption of responsibility, without recognising that on the facts of these cases, which the learned judge accepted were strong facts, and we adopt her analysis of the facts and have set those out in the skeleton argument at paragraph 8. I'm sorry, we've gone much further on in the judgment, but at paragraph 8 she sets out succinctly the facts that I've been taking the court to.
Yes.
On those facts, can one say, simply by looking at what has happened in other cases and found not to be something more, that on these facts a court couldn't find there was something more in terms of a full investigation of the facts?
But isn't the other part of 65, and isn't the whole point, however you describe the tasks or whatever word you use, the problem here is, what you are really saying is that there was an actionable failure about the way in which they exercised their Section 47 duty. There should have been an investigation. Why? You say because she made a specific complaint about her own father touching her breast and so on. But the argument against you is that Poole really says that if what you have is just the statutory regime that you're dealing with, and that is a statutory regime of investigating allegations about threats to the welfare of the child, that isn't enough. That's the starting point. But you need something more to show that not only are they doing for that particular allegation, no matter how it arose, what their statutory powers require, but you need something else as well, like the Blewett case, where the social worker actually helped her and said, no, don't stay in that hostel, stay in this hostel.
But there's the Section 47 statutory backdrop is always recognised is not in itself going to give rise to a breach of duty. It's going to be the specific actions. And I go back to the analysis of Lord Brown Wilkinson in terms of the school. If you decide to close a school, that's a discretionary act within your discretion, and you would have to be outside the ambit of it to be liable, but there could be a common law duty in the way that you run the school and what you do within the school, subject to whether there are policy considerations. But you can, in relation to running a school, we would say this is equivalent to the Section 47 investigation. Is something whether you decide to do Section 47 investigations or not may be a matter of discretion, but when you're doing them and you're doing them in relation to a particular child, and you have undertaken to look for a particular child at abuse that she has complained about, that can give rise to a duty of care, because it is the carrying out of the task. It's the running of the school rather than the decision whether to run a school at all or to close a school. And when you're looking at the specifics of a Section 47 investigation, you've got to look at what they're doing within that, and the statutory umbrella becomes irrelevant if you're in the common law duty. You're looking at what they're actually doing in common law principles, not as a statutory
No, the duty must be a
investigation.
duty to exercise your Section 47 powers properly. They weren't, and couldn't be criticised for anything else, did they?
Well, on the facts of HXA, they didn't need to investigate by carrying out a Section 47 investigation. If another route had been, well, that's so serious that we need to get an emergency protection order, that would have been a different way of safeguarding that child.
I appreciate you could say there might be an assumption of responsibility to do something properly, and that something should be Section 31 or it could be Section 47. But I thought that this case was all about really whether or not they had properly carried out the investigation, which, had they properly carried it out, would have led to Section 31 applications or something else. You really are complaining about their failure to investigate properly.
But that's the mechanism by which they, having assumed responsibility for looking into this child's complaint, they chose to do it through the mechanism of a Section 47 investigation and a child protection conference. They had a discretion as to how to investigate it, but what they did have to do, having assumed responsibility, was to do so
Non-negligently.
competently. And it was what they did in having a child protection conference that wasn't properly informed of the background was doing it negligently. But the fact that it is a child protection conference is irrelevant to the task they have to do. What they have to do is protect a child who's made a complaint about a sexual assault. And that can be carried out by a range of mechanisms. And the fact they choose one that has a statutory label can't rule out that there's an assumption of responsibility, because what I think is suggested by this, that because it's Section 47 investigations have been ruled out, I would say they haven't been ruled out, they just aren't enough for an assumption of responsibility. It doesn't mean you can't have an assumption of responsibility within a Section 47 investigation. You can if you have assumed responsibility on the particular facts. But you may have assumed responsibility, and you don't have to do it by a particular labelled investigation, but you do have to do it responsibly if you've taken on responsibility for that particular child.
So is the point that something more might emerge from a careful investigation of the facts seen against the statutory backdrop?
Yes, well, we say there's something more in this case was that the child had made a particular complaint and was, we would say, relying on the local authority to investigate that particular complaint.
That's age case.
Yes, and there's something more in the YXA is the Section 20 accommodation.
So if you complain to a neighbour, they don't have to assume responsibility, and even if they do, if they say, well, I'll speak to your father or speak to your mother, trying to work out the analogies, how does that matter? Because
well, the local authority wouldn't have assumed responsibility.
no, I wonder, the local authority is only liable in the same way that somebody else would be liable. So I'm trying to think of circumstances to test when being told that somebody's responsible, that you then have to take steps, and you would say it's not really analogous. You're not going to have a situation where you tell a friend or an uncle or a godparent that you've been assaulted, and if they don't do anything, it is because the local authority is under statutory duty, I think, isn't it?
Well, it's because they have the ability to protect the child, because that's why you would complain to the local authority.
Because they could take the Section 31 steps, or they could do the other thing.
They can do something. And you probably, if you complain to the neighbour would probably say you need to tell your social worker, or you need to tell the police.
Yeah.
Or would take the child to the police or the social worker, because the neighbour wouldn't assume responsibility for doing anything unless they could.
Yeah, all they would be responsible for is passing it on. If they promised to pass it on to the police and they didn't, then there may be an issue. But no, okay, I understand how you put it.
But once it gets passed on to social services and they say, yes, this sounds serious, we've got to do something about it, to then do it as incompetently as happened here, why shouldn't that be actionable? I don't think I can put it any differently from that, but those are. So I think that the complaint in terms of the judgment is really the comparison with other cases, and the fact, as we set out in the skeleton argument, that if you ultimately look at all the cases in which it's been said there isn't an assumption of responsibility, there's very little left that social services could ever do that would give rise to an assumption of responsibility. And then you would ask, well, why did Lord Reid say there could be an assumption of responsibility when he could have said, unless the child's in care as in Barrett, there's never going to be an assumption of responsibility. It must have been anticipated that there would be circumstances. Just CN and Poole wasn't one of them. But any other situation, effectively left for investigation on a case-by-case basis, at least initially, till the courts had an understanding of what more was required. And we would say these two cases are good examples of where there is more and where there ought to be a trial and an investigation of the facts before you can say that they haven't, at least arguably, assumed responsibility for these children who undoubtedly have suffered as a result of the actions of the local authority in these particular circumstances. I don't know if there's anything else I can... Sorry, I'm just asked to point out in paragraph 68 of Mrs J Stacey's judgment in relation to the keeping safe work, she comes to the conclusion, again, without that being able to be investigated
accept as a trial that there would be no causation, whereas in paragraphs 29 and 30 we specifically
Pleading causation, so she's forming a conclusion about causation on a strikeout application if the pleadings are.
So where do you say she's gone wrong?
in paragraph
68.
68.
Which line?
Proper analysis. Sorry.
Is it the second
Second
sentence?
sentence, my lord, yes. And we said
That's wrong.
in paragraphs 29 and
30 that we've looked at, they do plead causation.
Right. So paragraph 65, the judge is wrong.
Sorry, 68.
68. I meant 68. 68, the judgment is wrong.
And it's
Second
pleaded
sentence,
in
the second
29
sentence.
and 30.
Causation was pleaded. Okay. On paragraph 70. What do you say to what she says there? It is now well established there is no duty of care owed in relation to child protection functions generally, and the fact of section 20 temporary accommodation can't be used as a peg on which to assert this sumptuous responsibility. The imprecise statute in 22(3)A can't support a duty of care when none would otherwise exist. There is no logical reason why the provision of section 20 would make a difference. It does not amount to something else, etc.
Well, we say it does amount to something else. Because they are specifically taking a child into accommodation to keep it safe from the danger that they're taking it away from. And to do so and not prevent the child suffering the danger that's being taken away by keep sending it back is arguably an assumption of responsibility.
Thank you very much. Full force.
My Lords, my Lady, the circumstances in which a public authority can be liable in tort have been much considered by the appellate courts, as your Lordship's Ladyship has seen over the last 30 years, and quite a number of the cases have concerned social services, and various distinctions have come in and out of favour in helping to determine whether there is a duty of care on the part of the relevant public authority. For example, the policy operational dichotomy is no longer fashionable, and the distinction between acts and omissions remains, but it's been decided that that can be better expressed.
Yes.
And the pure policy considerations, which can give rise, in effect, to the conclusion that a duty of care is not owed, or the fair, just and reasonable ingredient of the analysis, since pool, are regarded as much less significant
Policy.
in the legal analysis. Yes. And the Human Rights Act, which has threatened on one or two occasions somewhat to blow the analysis off course, I think is now taking a much less prominent part in the analysis that this court
Yes.
and others have to perform. For example, when the case of Barrett came before the House of Lords, there was anxiety about the whole business of striking out in view of what the European Court of Human Rights had said. And one can see from what Lord Brown-Wilkinson said there that they were very concerned whether they should be striking anything out at all. Although a subsequent decision of the European Court of Human Rights in Z essentially proceeded on the basis that in Europe there had been a misunderstanding of what we meant by striking out.
Yes.
It was simply meant to deciding a matter
I've
in preliminary court.
in my head exactly the timetable. Z came after Enfield, didn't it?
Yes, it did.
Right. So
So
Z.
we were worried about Osman in those days.
Oh, that's right.
Yeah, because that appeared to suggest there would be a breach of Article 6 if you struck out a claim or might be. Therefore, that induced a certain nervousness, I think, on the part of the judges about the striking out procedure. That no longer seems to be a prevalent view because of Z. And similarly, whatever the status of D and East Berkshire in the Court of Appeal, and that's something that's been raised, one of the conclusions reached by Lord Phillips, the then Master of the Rolls, was that X and Bedfordshire, to use his words, could not survive the Human Rights Act.
Yes.
Now, I don't think that's any longer considered to be a satisfactory analysis. Subsequent decisions of the House of Lords and Supreme Court have suggested that, made clear, that a claim in the Human Rights Act and a claim in common law negligence are separate. And one doesn't, as it were, read into the analysis of whether there's a duty of care factors which might be relevant on a claim under the Human Rights Act. So, to that extent, there have been some simplicity. However, in view of these various historical trends, it is understandable, we accept, why the learned friends say that this is a developing area of the law. In one sense, I suppose one could say that common law is always developing and never comes fully to a halt. But as the Supreme Court has recently said, and made clear, we say, coherence and consistency are really important. There will always be minute, or even rather more than minute, factual variations in cases of a broadly similar nature. But if the law is clear, then there is no need for a Caparo-type analysis in every case, nor for a minute examination of differences on the facts of similar cases to decide whether or not there is or is not a duty of care. So that, although we wouldn't disagree with the fact that the law does develop, we say that in this area it is clear. And Lords, we would pay tribute to the very full judgments of the courts below, from Master Dagnall, from Deputy Master Bagot QC, from Mrs Justice Stacey, and in the DFX case from Mrs Justice Lambert. And Mrs Justice Stacey referred to Mrs Justice Lambert's analysis of the law, and we suggest that's really what she's borrowing from it, not an analysis of the facts, because she didn't have to do that. Certainly, the judgments from the Masters are the fullest that I can recall. The careful analysis of the law from those judgments means that our submissions, I think, can be shorter than they otherwise.
We haven't looked at the Masters and the Master's judgment or the Deputy Master's judgment. Oh, I say we haven't in court.
There is a helpful quotation, I think, from Deputy Master Bagot in Mrs Justice Stacey's. I don't think there's any significant difference in their analysis, but we do rely on the fact that very careful analysis by judges reaching the same conclusion is something of itself that the court should bear in mind. It's not suggested, for example, or wasn't suggested that the Deputy Master failed to take into account matters that they ought to have done, or there had been subsequent decisions which changed the analysis or anything of that sort. So they all speak effectively with one voice, we say. The skeleton arguments on both sides have ranged extensively over the area of the law, and Lordship's seen a considerable amount of the authorities. And in fact, the judgments below, there was a very substantial citation of authority, in particular Mrs Justice Stacey and Mrs Justice Lambert's judgments. But it is quite significant that the grounds of appeal are quite narrow, in fact. And if your Lordship's ladyship would be good enough to look at my learned friend's skeleton argument, they are helpfully set out at page 23. It's also in the bundle at page 41. I don't know whether you have the skeleton argument separately or not. So the grounds of appeal, one, in respect of both cases, wrong to strike out as unarguable when the facts...
sorry, where are you reading?
I'm reading under the grounds of appeal, which in the skeleton argument is paragraph 7, and at page, so right at the end of the skeleton argument.
Yes, sorry, I had it, forgive me. Yes?
So ground 1, in respect of both cases, the judge was wrong to strike out the claims as unarguable, when on the facts as pleaded, they had a strong case for showing there had been an assumption of responsibility. Wrong to strike out by comparison with other cases, where the comparison was flawed and the other cases weren't necessarily correctly decided. Wrong to accept, not to accept that this is a developing area of law, as the application in full has not been applied in a range of cases that local authorities deal with. And in the case of YXA, failure to find that a decision to take care proceedings was arguably an assumption of responsibility was plainly wrong. In YXA, the decision to carrying out safe work, and in YXA, the finding of accommodation, that's a section 20 point, distinguishable from the decision in Barrett and Enfield, plainly wrong. And in YXA, the failure to find the decision to accommodate YXA and the decision to place him back with his parents was plainly wrong too. So, in fact, I think it's fair to say that eventually those were the highlights of Learned Friend's submissions, but they are in fact quite narrow, although inevitably there was quite a lot of detail about the whole sorry tale, and we absolutely accept that these are sad cases. They are, sadly almost always are, where there were decisions that might have been taken, no doubt on imperfect facts, decisions which maybe in hindsight ought to have been taken, better information obtained, and the like. But of course, our submission is that the question of whether there is a duty of care has been considered at the highest level in these circumstances. And the learned friends have valiantly tried to isolate various aspects of each story and say this somehow allows them to circumvent the ratio of pool. And I think your lordships and the ladyship are now familiar with the core allegations in the two cases that we have to consider, and furthermore familiar with now having the learned friend helpfully taking you through Mrs Justice Lambert's decision of the core allegations in that case. But it may be helpful to remind the court of what was alleged in the Poole case, in the particulars of claim, which we in fact have added to the core bundle in this case. And if the court was good enough to look at the YXA bundle, so it's a supplemental bundle. It's yes. Mine is right at the end. Maybe your lordships have it separately. I'm sorry. It's at page 62 of the supplemental bundle. And it begins with the parties. We redacted, of course, the names to avoid inadvertent reference to anybody who could be identified. Very first sentence. This is a claim in negligence arising from the defendant's failure to protect the claimants from harm. It is important to remember that all these cases are effectively about failing to protect the claimants from harm. Then we see at page 64 the statutory backdrop, and at paragraph 2.1 there is reference made to the statutory duty to safeguard the welfare and promote the upbringing of all children in a local authority's geographical area. Specific references to sections 17 and 47, the 89 Act, and will rely on the particular reference to disabled children. There was then an analysis of the sequence of events, and if we go to page 8 of the pleading, page 69, the direct duty of care is identified. The defendant local authority was responsible for providing social services in the area of Poole and had a direct duty which included a duty to protect children in their area, and in particular children reported to them as being at foreseeable risk of harm. So that was very much the context in which this case was argued. And there are allegations of what it was alleged should have alerted the local authority to the problems they are having from the neighbours. And then at paragraph 6.2, at page 11, we have, in the light of this information, the defendant failed to assess the ability of the claimant's mother to protect her children from the level of abuse, did not carry out timely or competent risk assessments, and such assessments were flawed or delayed, failed to assess the ability to protect from the family next door and associates, failed to assess the mother, unable, on the balance of probabilities, this is paragraph 6.3, competent investigation at any stage would have led to the removal of the claimants from home. And then a child in need assessment should have competent care have been carried out. Nobody competent would have failed to carry out a detailed assessment. And if it had been, each of the claimants required removal from home. And with the information obtained, the defendant would have obtained at least a respite care, and if necessary by interim order, any competent local authority should and would have arranged for their removal from home, at least into temporary care. So that was the general structure of what was alleged in Poole. So my learned friend understandably tries to distinguish Poole in terms of the nature of the allegations from those cases before this court. But we say from the pleading, they are broadly along the same lines, albeit that the risk may have come from third parties rather than those in the house. Essentially what we're talking about is the local authority's duty towards these claimants, or putative duty. And the question was whether there was a duty on the part.
It was a duty to protect them from risk
from third
from
parties.
neighbours. And the question, first of all, is whether similar factual issues about assumption of duty and services would necessarily be capable of being transposed to a different situation. Duty to protect the children from the parents and the parents' live-in partners, because there might well be a very different set of information and very different factual circumstances.
There would be.
It doesn't really touch on the wide variety of circumstances that exist with abuse within the home, does it?
Well, we submit that if you look at what the proper ratio of Poole is, it's plainly wide enough to encompass all these situations. And perhaps it would be helpful.
Can I just ask a question on the pleaded case in Poole? I mean, wasn't this case as pleaded bound to fail? Because, as we've established, I think, in the course of the discussion, the local authority couldn't have relied on its Children Act powers to remove the children from their parents on the facts of this case.
Lady Justice King's alternative.
That's an alternative. And my lady's quite right to ask me that question, and I'll come to that when one sees the way that Lord Reid deals with it in a particular juncture at which he deals with it in his judgment. And it may be that on the facts that's absolutely correct. And of course, this was striking out, it never got to a detailed analysis of the facts. And Lady Justice's invaluable contribution, no doubt based on her experience, was able to inform the court as to what actually would not have happened on those particular facts. But it doesn't, in my view, make the rest of the observations of Lord Reid in any way obiter, particularly when he is seeking, we submit, to make it clear what the law is in this general area.
Yeah, but the Lord's right, isn't he, that the factual circumstances are significant, well, they are removed, they are some distance from where we are in these cases, because in these cases the complaint was the local authority failed to exercise its powers to protect the children from their parents, not that it failed to exercise any powers to protect the children and the rest of the family from neighbours.
But ultimately, if one looks at the legislative context, which is set out both in the Poole case and indeed in Mrs Justice Stacey, we're dealing with the same overall duty owed to children within a local authority's area, so that the local authority's duty is the same to the children, whatever the source of the risk of danger might be.
But it isn't, because the local authority could not have removed these children from their parents on the basis of the pleaded allegations of danger from the neighbours.
That may be so. That may be so in practical terms. I entirely accept that's what the judge said, but the overall context in which the court in that case was considering was what the powers of local authorities were generally is the case.
Well, it wasn't, but it wasn't. It was the court was considering the claim before it.
Yes.
On the facts before it. So I think isn't it putting it at its weakest, isn't it a little bit dangerous to draw sweeping inferences about local authority duties generally from a case like this, which is on rather strange facts?
I certainly hope I'm not going to draw any sweeping inferences. I hope to concentrate very much on what the court actually said and whether it's a true, what the true analysis of what the decision was. But of course, there are these factual differences, I accept, and there will always be, I suspect, a variety of different facts in these cases.
Well, factual and legal differences, aren't they? They're not just factual differences.
In terms of the powers that the local authority had. Indeed, but can I endeavour to answer my lady's question by looking at what the court actually said in Poole in terms of how they viewed the statutory position and whether or not the point that my lady makes invalidates the general judgment, or whether in fact it is as it were, something of an afternote, important afternote that may be. Can I take the court to the Poole decision?
Yes.
Which is at page 502, I dare say the court has it. The head note begins with the two claimants, both children, were within section 17 of the Children Act 1989. Letter E, although the claimant's claim was not one for breach of statutory duty, the common law duty of care asserted by them was said to derive from the defendant's duty under section 17 of the 1989 Act. So that was the way that it was put before the court. To safeguard and promote the welfare of children within its area who were in need, and its duty under section 47 to inquire as to whether action should be taken if it had reasonable cause to suspect that a child was suffering or likely to suffer significant harm. So the head note makes it quite clear that that was the prism through which the court was looking at this case. And the holding, I don't think I need, or perhaps it would be useful if I did in view of the challenge that I've received about this. Dismissing the appeal, that a public authority would owe a common law duty of care in circumstances where the principles applicable to private individuals or bodies would impose such a duty, unless such a duty of care would be inconsistent with, was therefore excluded by the legislation from which the public authority's powers or duties were derived, that a public authority did not owe a duty of care at common law merely because it had statutory powers or duties, even if by exercising its statutory functions it could prevent a person from suffering harm, but therefore a public authority could come under a common law duty to protect in circumstances where the principles applicable to private individuals or bodies would impose such a duty, as, for example, where the public authority had created a source of danger or had assumed responsibility to protect the claimant from harm, unless it would be inconsistent with the relevant legislation.
Yeah.
And of course, it is perhaps worth reminding the court, matter of fact, I'm sure they're entirely aware, that going back to Exeter and Bedfordshire, one of the things the court there and in subsequent cases did was to look at the statutory provisions and decide whether or not they themselves gave rise to a duty of care, because sometimes Parliament will specifically provide that there is a duty, sometimes on proper construction of the statutes, courts will conclude that that was not Parliament's intention, whether it explicitly said so or not. There's never been any doubt that the statutory background, the statutory provisions which are relevant, did not give rise to a duty of care.
So we're in the something more territory,
Yeah.
and we looked at the authorities and the emergence of the assumption of responsibility prism, right way to look at it, filter, hurdle. Would you accept that was, although it had appeared in other cases, the way it is expressed by Lord Reed in Poole marks a change of direction in these cases?
I don't think I would, I'm afraid, quite accept that. No, I mean, in the sense that the possibility of an assumption of responsibility exists in a number of different other contexts where public authorities are concerned. So, for example, I'll show the court probably tomorrow this particular extract, where one's dealing with the duty of the police, quite often considered by the courts, whether or not the police owe a duty to an individual, when normally, of course, their duty is to the public at large.
But in the context of this type of claim or potential claim against a local authority for this in these factual circumstances, was this a change of direction or touch on the tiller, which is a change of direction?
It may be a further elaboration. I wouldn't say it was a change of direction with respect. What this case seems to do is to change the way the duty or absence of duty is analysed, rather more, and this was a reflection of what had gone before in Robinson too, and in Michael, which is to say, rather than let's look at social services as a public authority and beam in on what they can and can't do. It was also to say, well, normally the position is exactly the same whether someone is a public authority or an individual. That was a change, I accept, in terms of the analysis and what Lord Reid brought to our understanding of the proper way to look at a duty of care. But he reached, we submit, a conclusion which was broadly consonant with what had gone before by accepting the fact that there might be an assumption of responsibility. He wasn't, as it were, we submit, opening the door to that being a likely consequence. He didn't, as Melanie Friend quite rightly says, postulate any particular circumstances in which there would be an assumption of responsibility. One wouldn't necessarily expect the Supreme Court or a judge at that level to give examples of that sort unless they were relevant to the decision.
But in those circumstances, isn't it, and bearing in mind the caution which has to be exercised when exercising the strikeout powers, is it appropriate to strike out claims in this way so quickly after the Poole decision?
Well, of course, that depends on what your lordships think Poole decided. Our submission is, and this was the conclusion of the lower courts, that it made the position sufficiently clear so that the case should be struck out. Now, I accept that was not the case in the DFX decision by Mrs Justice Lambert, where there was a trial, although we would submit that if one looks at the analysis by her, in fact, the trial was unnecessary because she would have come to that conclusion without their hearing evidence. In fact, she found against the claimants on the facts as well. But it isn't necessary for there to be a very long and very expensive trial. I mean, that's with the diversion of resources and the like, simply because there is a possibility of minute variation, or, as Melanie Friend says, if you look very closely, you might find on fact A or fact B, or fact VV, or whatever it might be in a pleading, that there was briefly an assumption of responsibility. We have to reflect, we submit, the overall ratio, which is common both to local authorities and to defendants generally, which is there is no duty on the part of a defendant to protect a claimant from the acts of third parties. That's what lies at the heart of the case, given the slight change in the analysis brought about by this case and the previous case, which reflects that. I'm conscious of
unless where the public authority created a source of danger,
yes,
or assumed responsibility to protect.
Yes,
from
I was mentioning, I can either do this now or later, I was mentioning the police as an example where there might be an assumption of responsibility, notwithstanding the fact that in a number of cases the courts have decided there is no duty of care owed by the police in terms of their investigation, however careless they might be or might be said to have been. For going back to the Hill and the Chief Constable case, which was the last victim of the Yorkshire Ripper, well-known case, the court decided insufficiently proximate and it was not fair, just and reasonable to impose a duty. Then came the Brooks case, where there was an individual who was identified and the Court of Appeal said, well, there might be proximity, but it still is this core immunity which you get from Hill. That has remained the law, and we see it again in the case of Michael more recently, and that's the case I will come to, if I may, tomorrow. But Michael does discuss, and I'll finish with this point, does discuss the possibility of an assumption of responsibility in the course of Lord Toulson's judgment, when he deals, for example, with a case called an Informer. There was also another case called Sweeney, where the police had undertaken to look after the safety of an informer, as one might imagine, and in Sweeney likewise informing on a violent criminal gang. The question was not whether they had assumed responsibility, but the extent of their assumption of responsibility. And the issue before the Court of Appeal in Informer was not whether or not they had assumed responsibility, but whether the assumption of responsibility extended beyond the physical safety of the individual, which it was conceded that it did, and whether it went to the economic losses which were actually suffered by an informer. So I cite that as an example of, it's an unusual case, it's against the grain. What Lord Reid was, we respectfully submit, very sensibly doing is, well, there might be an assumption of responsibility, but the best way to analyse this case is, here is a local authority exercising its statutory powers, as Mrs J Stacey said, is not, in the normal circumstances, possible to extract from that some duty.
Thank you. We'll rise now and resume at 10:30 tomorrow. Do you think between you we'll finish by the short adjournment tomorrow? I'm trying to find a way of saying what Ms Campbell said this morning. It depends on how often you're interrupted.
I was wondering if I could rephrase that in a different way, but of course it is.
There's no good way of putting that in my experience. At least I see so. No, I didn't think so when I was at the bar, but there isn't. So possibly not.
I think I can undertake not to spend too much time with the authorities.
Thank you very much.
I just mentioned that they never reached the bundle of authorities because we didn't provide it, the framework for the assessment of children in need, which we refer to in our skeleton argument, and there are now copies available of that because it's referred to in the skeleton.
Okay, well, I've got that somewhere else. But we'll have copies of those. Thank you very much. Thank you very much.